The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can see the program on Sunday afternoon at 1 o'clock, and again it's repeated Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. Parents that are having problems with the DHS or receive a letter from the DHS concerning their children, we have a lot of information that we've accumulated over the years from experience. So we try to help you. We're not attorneys, but we have knowledge to share. My number is 276-3956, and John's number is 282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa. It's those issues that we spend a good deal of volunteer time. Number one, to assist in influencing public policy as it relates to child abuse issues. And secondly, to do hands-on, that is to interact with parents who are having difficulties with the Department of Human Services, and there's a few of those kind of cases going on. There are over 5,000 children in Iowa who are in foster care today. You see 5,000, when you think of that, that's a magnificent that would be a magnificently large community in Iowa. Not many communities in Iowa have populations of over 5,000. So that would certainly be a big small town, wouldn't it? And it would be bigger than most of our suburbs, most of our villages around the state. What that boils down to is it is vastly expensive to pull children out of the home. However, it seems as though it is an income producer for many people, many providers, and for many social workers. If you have a child under the care and nurturing of a good mother and a good father, we don't need all that work. So it becomes incumbent sometimes, we believe, to pull children away from good parents, or even parents who have some degree of weakness. It's incumbent upon the department to separate those children from their parents. Otherwise, we don't have the raw materials necessary to go and knock on the legislator's door and say, we need more money. At one point when I was studying these figures, found that the Department of Human Services had a budget at that point of federal and state dollars of $2.3 billion. That's billion with a B. $2.3 billion. I have no idea how many workers are, but it goes up into the thousands of workers. And whether they get these children legitimately or whether they get them through theft and deception, the same thing is true. It is good for the agency financially to grab as many as they can and get them into foster placement. It also runs up the dockets on the juvenile court. And our chief judge of the Supreme Court wants to do something about it. I haven't heard the chief judge mention anything about reducing the dockets or reducing the method by which we go out and steal children. But she is certain that she wants to do something to help the children. Well, a lot of things are happening in our state legislature, and a lot of bills are being put into the bins for consideration. Don, would you read a bill called Senate File 210? This is a bill that is supposed to help parents who have newborns. Senate File 210. Do you have trouble finding it? It was on top.
No, I have it here all the time, John.
Okay, you bet. Okay, let's find out the most effective way of taking care of newborns. Don?
The Iowa Empowerment Board shall implement a program with the goal of making available a home visit for each household in the state with a family that has a newborn child. The components of the home visit shall include, but are not limited to, assessing the child's home environment, educating the family concerning newborn children. I like that, John. The system knows how to educate newborn, pertaining to newborn children.
You see, we weren't able to do that in the centuries before empowerment boards, did we?
And assisting families in assessing appropriate services. Sure, through the DHS and things like that. The DHS knows all about parenting. Well, anyway, I'll go on. The Iowa Board shall coordinate with existing programs that provide a visit to the families with a newborn child as necessary to make the best use of resources while expanding the availability of home visits. The home visit program implemented under this section shall be administered by the local level through the local Board of Health as defined in section 137.2. The following requirements shall apply to local programs receiving funding under the program. A. Home visits shall be made by qualified and trained staff. B. The program staff shall demonstrate a capacity to competently complete home visits and facilitate referrals to and interventions by other resources available in the community based upon needs identified during a home visit. That's one of the key issues, based upon needs identified during a home visit. The local program must have an acceptable plan for implementing a cooperative arrangement with local hospitals and birthing centers for the hospitals and centers to provide referral information for contacting families with a newborn child. The local program must have the capacity to bill third-party payers as appropriate and to leverage additional resources such as local cash or in-kind matching contributions to sustain and enhance the local program. The local program must apply performance measures identified by the Iowa Board and the local program. Administrator, I'm not sure the way they write up this bill, and the local program administrator and shall report outcome information on a regular basis identified by the Iowa Board. Got numbers. Let me put that up there so you can see what I'm reading off of, and there's numbers off to the side, and trying to keep the numbers out of my speech here, even though it's in the bill. Number 3, the Iowa Board, see there's a time for a number in there, I just put it in there. Number 3, the Iowa Board shall implement the provisions of this section subject to the funding provided for purposes of this section. And then they put an explanation in here. This bill establishes a program for providing home visits for all families in the state with a newborn child. John, when I'm done reading this explanation, would you tell the audience whether you agree that the explanation is explaining the bill as it's written? Because I've seen times in the past where the explanation is written up totally different than the bill itself, and most people only read the explanation and think that is what they're going to vote on.
I think you just explained it.
Oh. This bill establishes a program for providing home visits for all families in the state with a newborn child. New Code Section 2811 directs the Iowa Empowerment Board to implement the program with the goal of making available a home visit for each household in the state. Well, wow, John, your household, are you going to get visited here? Everybody, it says, each household in the state with a family that has a, oh, then it goes on, well, you don't have a newborn child, so
Yeah,
you won't
you
fall
got to have a family to qualify.
at least a newborn child. The board is required to coordinate this program with the existing programs providing home visits to families with a newborn child. The program at the local level is required to use the local Board of Health as an administrator. The bill includes requirements for the local board. The Iowa Empowerment Board's implementation of the program is subject to the funding provided for purposes of the program. John, uh, is this going to be a forced requirement on everybody that just had a baby born in their family?
It doesn't appear to that, but have you ever seen a program come in as a voluntary program and somehow get switched over to a mandatory program? You know, seatbelts were voluntary at first.
So were income taxes,
Income tax is a voluntary program.
and it's supposed to be still voluntary,
That's right, but it isn't.
but it's mandatory if you don't pay them.
That's right.
Mandatory to go straight to prison for life,
Yep.
huh?
That's right. So voluntary only applies until after you get the state legislature to vote for it. Voluntary is the foot in the door. It just seems. By the way, there's something else that's kind of sinister about this, because if they don't volunteer, this is what DHS does if they offer services to parents in the hospital. If they don't take the voluntary services, then they're on the to-do list for watching very carefully over this family, because who knows what might happen to a family if they don't follow DHS agenda. If you're not persuaded to accept the DHS, you might be on their list. And they can, number one, in your child abuse report, it simply say, services were offered, but this family declined. And because they declined the services, they are now before the juvenile court to have their kids snatched. I don't think they use those particular terms, but that's what happens, what could happen to children. Back to the bill, Senate File 210. This was a bill filed by Bolcom, B-O-L-K-C-O-M. Bolcom is I think he's been around the legislature for a little while, but he is from Iowa City. I heard a speaker one time who had an engagement in Iowa City. He said, before coming to Iowa, I thought Iowa City was a part of Iowa. Well, Iowa City has a political climate that is far outside of small-town Iowa. And so when you find a bill like this, it's good to look up to see where these sponsors are. And State Senator Bolcom is from Iowa City. So you can expect great things from a liberal senator. I'm going to introduce a topic here, and then we're going to switch in just a moment to Terrance Walker. Terrance Walker has taken an extended vacation. I think he was on a tour or something, because we haven't seen him for some time. and
He was on that cruise, and he
uh,
got sick.
oh, is that it?
Oh, yeah, I
Okay.
assume he did.
Yeah.
He got sick and probably laid in the hospital for a year.
He
Well,
probably
that's news to me.
he probably got sick of not being paid on television. But back to Senate File 210, I wanted to give you just a wee bit of history on this. You probably need some historical background on Senate File 210. Once upon a time, before Iowa empowerment boards, God invented grandparents to make sure newborns had a good start. That's worked for several centuries, and it did not cost the Iowa Treasury anything. Today, grandparents are put in the back seat, the ones that aren't thrown in the trunk, and their rights and the privileges that grandchildren have to be around their grandparents has been curtailed.
They've been put
I
in a
talk
boot, John. They've been booted into the boot. The
You
boot
bet.
is the uh,
Trunk.
trunk.
Okay, so now grandparents are, for the most part, second-class citizens, even though for centuries in the development of this country, parents and grandparents and great-grandparents were counted on as big assets, particularly to young families. Now we have to institutionalize it. Now we have to let government do it. And notice when Don was reading through that Senate File 210, these children they now have the privilege of being cared for by professionals, people who know all about um, raising children. Of course, grandparents don't know. They aren't professional at raising children. So now we're going to have full-time staffs and supervisors and accountability for the way they spend funds. Grandparents never had to worry about writing reports and accountability details because they provided the funding necessary to support those children. In fact, God had a great idea. He thought it would be a nice arrangement to have two sets of grandparents. Grandparents on the father's side and grandparents on the mother's side. This would be a real good support if one set of grandparents couldn't take over and assist. The second set could be called to assist the new family. And I think it's really great when Grandma gets on the phone and says, "I'll be gone for a little bit because my Susie in Arkansas is having a baby." And I'll be back in 3 or 4 weeks when things are cleared out of the way. Wouldn't it be terrible if Susie in Arkansas would have to wait for government to arrange their schedule so that professionals could do what Grandma has been doing up till now? Well, that once upon a time is now history, because a senator from Iowa City believes it should be government's job to do the parenting. I talked to a grandmother just today who has a number of grandchildren who are in very sad situation. In fact, they are in as many foster homes, scattered as many foster homes as there are grandchildren. So none of the grandchildren are with siblings. And grandmother would very much like to have a hand in remediating this situation. So she's doing the best she can under the circumstances, because the judge is not a real friendly judge, and the prosecutor is anything but a friendly prosecutor. So these kids are probably wind up in foster care, because foster care is the greatest thing ever invented, according to the people that run the show. The Department of Human Services and the providers of foster care services. 5,000 strong, 5,000 children now in foster care at taxpayer expense. Sad situation, isn't it?
And John, we just heard a couple days ago that there's 60 children in Iowa up for adoption. That's a lot of children, and that's just right now.
Who need grandparents and others to take care of them, but they'll pass up what they call kin care and pass these people off. In fact, in some cases, I've heard that the word gets around pretty fast. If we can get this child freed from his parents, you can have him. One social worker will say to another.
And not free. They just jerk them out of the home.
Sure.
And then they're headed for termination of parenting rights, and the parents didn't even know it was happening.
Yep, sure can. Okay, I want to talk about a couple of things today. Two stories, two strikingly the same. One is about Elizabeth Morgan. We may not have time to go into her case extensively, but we have a local case that is so strikingly similar to that. But it also, while it has some similarities, it also has some striking differences. And I want to point out the differences if I can. We've had a person on the air here, so we feel somewhat comfortable about talking, at least in generalities, about the case. We want to be careful not to say things that would be inordinate. And I want to talk a little bit about, at the beginning here, we have a number of times seen cases where there are divorces. And a spouse thinks that in a divorce case, all they have to do is say child abuse, child abuse, child abuse, and the judge will respond with giving them all kinds of assistance and help because they simply say that the spouse is abusing the child. Some judges are becoming acclimated to this. They are picking up what the shrinks are now calling insight. They're picking up a little bit of what's wrong in a situation where they're talking too much about child abuse when it may not even be occurring. So when I hear a woman who says, my child has been abused by the father, I tend to withhold judgment in that case. For one thing, it is almost impossible to prove child sexual abuse. I don't excuse it, but it's almost impossible to prove it. And secondly, these things can be expected in cases of divorce where people think they can use the department to bolster their case where there is no other reason for bolstering their case. 70-80% of the divorces are initiated by women. And women think that they can get a good leg up in court if they only say child abuse. So I tend to side with the accused in these situations. In the situation we're talking about today, it's becoming more and more difficult to accept the innocence of one of the spouses because of information that we have seen and heard about. So while I cannot make a judgment, because that's not my job to make a judgment as to whether the father is guilty, I think that we have to look at the cases and make some kinds of determination of what is best for the child under the circumstances. In this particular case, the child in the divorce case was awarded custodial care by the mother. And the case actually turned around while the mother was accusing the father of abuse, the court decided to ignore that, even though there was enormous amount of evidence to indicate child sexual abuse. So now the court has drumming up all kinds of support against the mother, and the child was removed from the mother's care only to place the child in the care of the father, the accused person. Now, if he was falsely accused, that may have been the appropriate thing, but the evidence certainly doesn't weigh in that area. So after we talk to Terrance, I want to look at something called a dissenting opinion, because there were some appeals as this case progressed through the court, and there is one justice in the Supreme Court that must set about to read things and must set about to think about things. And we may not have time to go through the entire case, the entire dissenting opinion. Dissenting opinions simply say, I'm in the minority, and I realize I'm in the minority, but here's the reason why I want to remain in the minority, opposed to the opinion of this court. There's three judges that sit on each of these panels. And this particular judge says, I respectfully dissent. A dissenting opinion is not controlling. A dissenting opinion, however, should never be completely ignored, because it indicates that there is a significant difference of opinion as to how the case should be handled. No way should there be a termination of parental rights where there is a significant and clear-cut dissenting opinion. And we'll let you decide that when you hear the opinion. Right now, let's turn to Terrance Walker, see what Terrance has to say about some of these issues in the courts around Iowa and around the nation. Here now, Terrance Walker.
Yeah, thanks a lot, John. Boy, it's good to be on the show, and I was sitting there enjoying your commentary there. So, and it made me reflect on the fact that you guys do a great work, in service to the community and discussing these issues, because I don't think anybody else is out there doing these sort of things. And we need someone to do these sort of things, discuss these issues in a public format that's not getting paid for it, because that's real value. When you have somebody that's getting paid for it, they might be influenced by what they're getting paid for. But when you have somebody that's not getting paid for it, then you have somebody that has something truly from their heart to say most of the time. But what I was going to say, you saying some good things about dissenting opinions, and I think I'm going to start with my first story that I had to talk about here, which was in the Des Moines Register here this Wednesday, February 21st, which I have to know is Black History Month. The dissenting opinion in a case involving the detainees, and this is involving the courts. I'm, of course, the judge of the judges here in the state of Iowa, because nobody else can do it. What we have here in this appeals court ruling, which recently has just came down from the D.C. Circuit, basically dismissed hundreds of cases filed by foreign-born detainees and which also threatens to strip away court access to millions of lawful permanent residents who currently reside in the United States. And basically this appeal was filed by a detainee at the Guantanamo Bay facility, which is off the coast of Florida and Cuba, I believe. They basically are saying that the detainees do not have any rights in the courts, which you know, may be a valid uh, holding. The dissenting judge, however, says that the military hearings, which they're saying give the detainees due process, uh, deprive the detainees of critical due threats, which, I think is a very valid argument. We've got on the cornerstone of America and the foundation of America, the people that established America fought very vigilantly for human rights. And I think that it's totally, we turn the tide 180 degrees when we go to not only denying people rights, but saying that we can hold them indefinitely and not give them any sort of hearing except for in front of the same military people that have detained them. And I think that we need to really look on this because not only does it have wide-reaching implications for the larger population, but it also has, more importantly, um, very bad implications for people that just reside here, who, may just happen look suspicious or be of a suspicious ethnicity, or for whatever reason is the person or the people to be picked on for the day. There's some 12 million lawful permanent residents in the United States, and a spokeswoman for the Judiciary Committee chairman, Patrick Leahy, who's out of Vermont, has basically said that Leahy has prioritized a bill that would restore detainees' legal rights, noting that some 12 million lawful permanent residents currently reside in the United States, and they could also be stripped of their rights. And there is currently an appeal pending, which is basically getting ready to strip all permanent legal residents of their rights to access to the court. So, we've had, over the past 10 years, we've had a significant curtailing of rights as it pertains to habeas corpus and people being heard at the federal level if they've been put in jail or something like that on a federal right. Now here we have, a further stripping away of rights, and I think it's a very dangerous trend. And I think that we're going, like I said, 180 degrees on to which, where we started at in this country, where, the whole thing with human rights, individual rights was so highly looked upon, and now it's actually shunned. And, it's a dangerous precedent to be set. But hopefully that changes. More kind of on the local front here, I've got an interesting story here, and I think we should probably put that one on there. Could you put that one on the TV screen for me, Don? We've got a guy here. I know this has occurred a couple months ago, but I haven't been on this show for a while. Been busy with business. I wish I'd been on a cruise. I need a break. I've been working so hard, doing my business. But we've got a guy here who we know as John III. His name is John Tennecat. This is from Des Moines Register, December 28th. The guy, Des Moines man refuses to ID to police. And his name is John Tennecat, 34. He refused to identify himself to a downtown police officer. And he changed his mind, he says, when he learned he was going to jail. And this is so fitting of John to say this, but he asked the police officer could he be unarrested after he identified himself. And, of course, the officer, Garth Howe, said no, it doesn't work that way. But anyway, he was charged with harassment, of all things, harassment of a public official for not identifying themselves. Now, you think about this. How can you harass somebody by not telling them something? That's like the pot calling the kettle black, I would think. But anyway, he was 415 in the alley downtown. I think he was debating, from what John told me, he was debating whether he was going to ride a bus or park his bike in the alley and or ride the bus after he parked his bike in the alley. Um, and I think he was trying to find a place to lock his bike. But anyway, the police officer accosted him and said, "What's your ID? Give me your name," and all that. And of course, John, being the man that he is, he is I guess he challenges authority when he doesn't feel he's done nothing wrong. He said, "Well, I don't have to show you my ID." So he said he didn't have to give it. Well, he got arrested, thrown in jail, and he's got a pending still. There's some charges on harassment of a police officer, I believe. But it's kind of interesting that the ACLU or ICLU, Iowa Civil Rights Union, Iowa Civil Liberties Union, has basically went on record on this Des Moines Register article as saying that he didn't do anything wrong. He did not refuse to leave, and basically said that the police officers or the police department should apologize to him.
It's my understanding that was basically a public place where he was at. I mean, it was an area where a lot of people frequent, correct?
Right, and it looks like it was an alley. I think there's some confusion there. The police officer said that it was a private place. John thought it was a public place because it was an alley, which, I would think most alleys are public. But I think public or private, I don't think we should have to submit our ID. And I would say, going back to the previous story, what if he didn't submit his ID? What if we're going to assume that he's an unlawful resident? Can we take him to Guantanamo Bay and hold him there indefinitely? So we're setting some dangerous precedents because these things, some of these things may happen, and, they could just argue, well, this guy looks like he may have a little bit of foreign blood in him, so let's just take him to Guantanamo Bay and hold him there indefinitely because he looks like he might not be from the United States, and we'll just keep him there and hold him there, and he doesn't have any access to the courts anymore. We'll just keep him there indefinitely. So these are some of the things we need to think about as it pertains to the courts and individual rights, and we should really be impressing upon the need to have these rights, including the right to refuse to identify yourself. I know there's cases where if you're suspected of criminal activity, where it is not a violation of constitutional law for the police to demand your ID at that time. But if you're going down an alley, with a bike, and you're not doing anything criminal, and the police did not, let me point this out, the police did not articulate that he was doing anything criminal. The police basically on the complaint basically said that he refused to give an ID. Now, I mean, that might have been a violation of the law back in Germany and, World War II times, or, any of the communist countries, even to this day. But, I mean, if we're going to be a nation of individual rights, which we were founded upon individual rights and human rights, I mean, we've got to make sure that we're not letting these kind of things happen. I think we really need to be vigilant and hard on these courts and people that kind of implement these measures, and impress upon them the need to keep and maintain our rights and not shun our rights, because we're going to end up being a communist country, even though a lot of the legislatures and stuff like that supposedly abhor all these communist countries and these dictators, and yet we have policies and court action and police action which shows that we are in effect leaning toward that way. But one other thing I was going to say, then I'm going to hand the mic back to you. I think that I had a occasion to talk to the prosecutor in this case. His name was Alubumne. He's African descent, and he's actually from Africa. But I talked to him. He's the prosecutor on the case. I actually met him at Drake Law Library about 6 or 7 years ago, and of course he didn't want to talk to me about the case. Ethical rules forbid me to talk to the case, but I did kind of like say, hey, you gonna put my buddy in jail for refusing to give an ID? And well, I can't talk about the case. But it's good that we do have a prosecutor that is of African descent. I mean, I do think that's a good thing, but I think Alu, you're going too far on this one. I think we should dismiss this case and get on with we got bigger fish to fry. You know.
That's right. That's right.
But that's my 2 cents on that.
Okay.
Is it true that Mr. Tennecat was not carrying? Oh, excuse me, John.
Yeah,
I'll
go
turn
ahead.
it over
No,
to
go,
you.
No, go ahead.
That's all right. Go ahead.
Okay. No, he didn't. He wasn't carrying any ID. Just a couple of notes here. Number one, I would be approaching, if I were still married, my 30th wedding anniversary at this time. I don't know whether it's 29 or 30. You know, husbands aren't supposed to remember, right? And I'm not even a husband, so a former husband. There is one thing I do know, however. The former spouse has just hit the big 6'5", and so that birthday and anniversary come about the same time, one day apart. So 6'5" and something close to either 2'9" or 3'0" are the important numbers right now, and those numbers keep coming around every time February 24th and 25th pop up.
We need a name, John. You got a first name or
no?
anything?
I think I'll bypass names. I said we'd bypass names with respect to the case that we're talking about. However,
Did you send her out a Valentine?
no, no, I haven't gone out of my way.
Okay.
The one thing that I said that we try to eradicate the names of the actual family we're talking about here. When the case talks about them, it puts in initials, but we'll not even use the initials as we try to hurry through this. However, I will not use that same rule when I talk about the officials. These are officials whose names need to be out before the public. They are public servants. They are paid out of public trough. And I think that if there's any honor to be had, those officials should get the honor. If there's anything less than accolades, perhaps they should be treated to those as well. In this particular case, mother was told that she could not take her child for any kind of an examination for sexual abuse herself. In other words, she had to be under the control of the Department of Human Services. Whether she could get to them or not, she had to wait until somebody in the department said, it's okay, you can exercise your individual civil liberties if we say so. So this is the situation. She decided that with a video camera, 2 hours after the child returned home from a visit with father, and the child was injured in the vaginal area. And mother took extremely good pictures of the injuries. For that, she had to face all kinds of reckoning. However, they thought about criminal charges, but they knew that criminal charges couldn't stick. They thought about writing a child abuse report against her. They knew that they would be in trouble if they did that. Luckily, they didn't do either one because they knew that this was a good faith effort on her part. However, they did the next best, dirtiest thing. They simply swiped her child. And that was on January the 19th in 2006. and she has not had that child sleeping in her bed ever since. That child hasn't come home and, to say, "I'm home, Mom." That child hasn't seen her home in over a year. So, with that modification of placement, the mother decided to go to the Iowa Supreme Court and says, "Is this right?" Well, the Iowa Supreme Court said, "Yes. We affirm the placement of the modification order." This was heard by 3 judges. Sackett did something that we've never seen her do before, and I think it was totally inappropriate. Sackett is one that we admire. But Sackett said that she concurred specially, and Warren dissents. Now, here's what Sackett said, concurring specially. "I concur with the majority. This is a difficult case." Well, I don't think they should be taken to court if they're not difficult cases. "Given the required deference to the experienced juvenile judge, I would affirm." In other words, she's saying, I'm not going to take a position for or against this judge because, after all, this judge is experienced. They can do that when it comes time to do things that have to do with credibility, because you cannot read a brief and determine credibility. Credibility isn't written into the brief.
Who's the judge
You have to
she's
be-
talking about?
This is Judge Sackett.
Judge, who's she
Well,
protecting?
she's deferring to the lower court judge, which is our friend down there, Carla.
Would you want to rephrase that again?
Carla Fultz, your friend, not mine.
Would you rephrase that again, please?
Okay.
We don't want that to stick into people's
You mean
minds.
strike that from the record?
Strike
Okay,
that
strike
from
it
the
from the
record about friends.
So she says it's a difficult case in giving the required. She's not required to give deference to the experienced juvenile judge. And based upon that requirement that she pretended to be in place, she concurred with the other elderly judge that ruled against this mother. But Weisbrand said this: "I respectfully dissent from the majority's conclusion that there was clear and convincing evidence to support the juvenile court's placement modification ruling. Number one, independent evidence of abuse. I believe there was credible evidence from the sources other than the mother that the child was abused. Around October 2003, the child apprised her mother, brothers, and a family friend that her father was touched her inappropriately in her crotch area. At that time, a transitional housing coordinator with whom the mother was working advised her to immediately report this to relevant authorities and to have the child evaluated by Dr. Riswan Shah, a specialist in child sexual abuse diagnosis. The mother followed this recommendation and took the child to a local hospital. This was the first time that the mother sought to have the child examined for signs of sexual abuse. This is a long way away from the Elizabeth Morgan case, where they went from doctor to doctor. Approximately 1 month after Dr. Shaw examined the child, the mother reported to her physician that the child returned from a visit with bruises on her face, and the physician informed the mother that if she suspects that the patient had physical abuse, she should bring her to the office within 24 hours to be examined and have pictures taken. The physician also noted that he had spoken to Dr. Shaw, and she recommended sending the child to short-term play therapy. I don't go along with play therapy, but
This is adult play therapy you're talking about, not children's play therapy.
No,
There's
well,
a
it's
difference.
It's goofy therapy talk. Mother initiated therapy with her child the following month, and after the doctor's visit, the mother reported the child's facial injuries to police. They took pictures of the bruises on the child's right cheek. Several days later, the mother took the child to the clinic for evaluation of the child's face. And while the physician did not see the evidence of bruising, a subsequent visit did reveal, um, I'm not even going to try to name the skin injury, but it was an abrasion to the labial area internally. Mother continued taking the child to weekly therapy sessions as instructed, and on July the 12th, 2004, therapist Lisa Walton decided to speak directly to the child about the mother's suspicions of sexual abuse. In a progress note, Walton reported the following. Today, the patient stated that her dad licks her, and the patient pointed to her tongue and stuck her tongue out and wiggled her tongue. And when he asked where she pointed, she pointed to her neck, both sides, and her belly. It sounds rather affectionate, doesn't it? Patient reluctant to talk more, and a week later, during another therapy session with Dr. Walton, with Walton, the child again disclosed that she had been inappropriately touched by her father. Walton's progress note summarized the conversation as follows. During the session, the patient was asked if she remembered what we discussed last week, and she said yes. And then she pointed to her tongue, asked if Daddy does anything with his tongue, and she points to her vagina. Ask her to identify the male genitalia, and she said pee-pee. The patient also said it hurts. By the way, this child is 4 years old at the time we first knew her anyhow. The patient also stated it hurts. And when asked what else does Daddy touch you with, she stated tongue, fingers, pee-pee, and pointed and grabbed her bottom and her vagina. Report was made to DHS. Now, is this mother initiating these reports, or is this the professionals making these referrals? When you hear them talk about removing the child from her mother's care, it says that the mother initiated these reports. No, the mother was protective. The mother sought help from professionals. The professionals made the referrals. Thank you. And only one of the judges bothered to read enough of the documentation to come up with the right reasoning. According to the police report, the mother reported that she was preparing to wash her daughter's pants when she noticed a white stain in the crotch. She feared that the stain was Richard's semen. Richard is the name of the father in this case. I probably shouldn't have used the name. He's the accused. The police officer decided to speak directly to the child. The child indicated that she was inappropriately touched, and the officer summarized the conversation as follows. I asked her how old she was, and she told me she was 3. I asked her if she liked Daddy, and she said, no, he's bad. I then asked, he was bad? He's a bad daddy? And she then said yes. And I asked her, how is he bad? Then she held up 3 fingers and said, fingers. And I asked her what that meant. And she repeated herself, and I asked her again. And she says, fingers. I asked her what Daddy did with his fingers, and she grabbed her crotch. Now, is there enough information in those responses to at least give you some sense of a problem here? None of this may be true, but I think that caution is indicated, and this was the only justice or judge in the Iowa Supreme Court of the Iowa Court of Appeals that recognized there were some problems here, and she didn't like what the juvenile court was doing.
And I think, can I say one
Sure,
quick thing?
go right ahead.
And I think, we ought to be very supportive of this judge. I mean, her name is Vaitaswaran. I can't pronounce that right.
Right.
But I did notice on the last vote out campaign, on the last retention vote this past November, that she had the most no votes. Well, I mean, I know a lot of that may have the unfamiliarity of her name might have played a role in that, but I mean, this is a judge that actually apparently pays a lot of attention to detail, and we should commend judges like this, and we should definitely vote to retain judges like this.
By all means, thank you for that note. At least, it's important to me that they read this stuff. And you cannot go through this dissenting opinion without a firm belief that the person who wrote it did some thinking, did some reading, and did some thinking. And that is very difficult to do when you have a case that is at least this thick, first volume. And by the way, they've spent hundreds of thousands of dollars on this case. They don't mind because it's taxpayers' money, and it doesn't come out of their personal pockets. In fact, it enriches the pockets of all these therapists, like John Stanley, who works for an organization called LifeWorks. He indicates that this child should go through TPR because the mother has done harm to the child. How did the mother do harm to the child? The mother had a fuss with John Stanley, who supervised visitation. The little child put her hands over her ears during this time. Don't you suppose a 5-year-old might be offended when somebody is attacking her mother? And she put her hands over her ears. John Stanley said that was harm, and when cross-examined, John Stanley said, well, it was distressing. So now, because the child encounters distress, John Stanley, who is paid by the state taxpayers, is indicating that child should be taken from her mother. And they agree that that in and of itself is harmful, very harmful. Even the ones that are pushing this whole thing say it's harmful. Well, in closing, however, the mother's housing coordinator noted that that mother had difficulty contacting her attorney and the department employees on the weekend, so she did the checking herself, turned the information that she got over to experts in the field. Department had lost patience with the mother and her allegations. Given this dilemma, I would conclude that the mother's act of filming the child was not grounds to modify the child's placement. And as a result, the transfer of the mother went from having TD for all but 6 to 30 hours of a 168-hour week to having only 2 hours a week. We're going to show this mother a thing or two. We're going to take her child away from her, and she's not going to be able to see her child but only 2 hours a week. Furthermore, they gave the child to the one who was being accused of the child abuse. Here's a couple of numbers that may be helpful to you in your struggles against the Department of Human Services. See you next week.